Welcome to this Legal Aid New South Wales Law for Community Worker webinar, Victim Impact Statements. My name is Bridget Barker and I work in the Community Legal Education branch at Legal Aid New South Wales. Your presenter today is Julia Brown, a solicitor within the Domestic Violence Unit of Legal Aid New South Wales. Good morning, Julia.
Good morning, Bridget. I too would like to acknowledge the traditional owners of the land where I live and work, the Gadigal people of the Eora Nation, and pay my respects to elders past and present, and extend my respect to Aboriginal colleagues online with us today.
Julia, I'll just say one more thing. Sorry, I should have covered this earlier, but just to let people know, the session will go for an hour and it includes question time, and there is an evaluation survey, and we do really appreciate when people complete it because we always look at suggestions for other topics that you'd like us to run legal webinars on. And now I'll hand over to you, Julia. Thank you.
Thanks, Bridget. So as Bridget mentioned, I'm a solicitor with the Domestic Violence Unit, and we work with people who have experienced or are experiencing violence. Before we get started, if anyone finds this content confronting, please feel free to take a break or get in contact with me after the session. So today's webinar will include what is a victim impact statement, or sometimes referred to as a VIS, who is eligible to make a VIS, what can a VIS contain, what happens after a VIS is prepared, and how you can assist someone prepare a VIS. I'll use the term victim throughout the presentation because of its legal meaning, but as we all know, these people are survivors of crime and much more than their experience with the criminal justice setting. So firstly, what is a victim impact statement? A victim impact statement is a written statement that tells the court any harm suffered as a result of a criminal offence. It includes details of how the offence that the offender has been found guilty of has affected the life of the victim. They can come in different forms. Most often they are a written statement, but they also can be a drawing. They can contain a photograph or other images. They can also attach medical reports and other supporting documents. A victim impact statement provides two functions, instrumental and expressive. The instrumental function of a victim impact statement is to inform the court of the physical or emotional harm suffered by the victim as a result of an offence, to assist the court determine a proportionate punishment. There are many purposes of sentencing, and one of them is to recognise the harm done to a victim of crime and to the community. So a victim impact statement ensures that the full effect of the crime is placed before the court. Now, this is particularly relevant where an offender pleads guilty and there's limited evidence before the court about the impact. And in New South Wales, over 80% of criminal matters result in a guilty plea. With there was a question that that came up already about this, and it's a very common question. Does a victim impact statement increase a sentence or impact a sentence? The short answer is mostly no. The victim impact statement, it assists the court in determining an appropriate sentence, but that is the role of the court with or without a victim impact statement. And when there is no victim impact statement, a court cannot assume that there has been no harm done to the victim. It only really impacts a sentence in terms of the length or conditions if it goes to proving an aggravating factor. So one of many aggravating factors in New South Wales that can be taken into account in figuring out the right sentence by the court is when the harm or damage caused is substantial. So in some cases, the prosecution may ask the court to take into consideration a victim impact statement when the offence has caused substantial harm to the victim. So an example of that might be where the offending can be directly linked to the development of a mental health issue or condition like post-traumatic stress disorder. So the prosecution in that case could apply for that harm to be considered as an aggravating factor and to increase the sentence. But generally in those cases, you would need evidence to prove that. So that might be an independent psych report or some other report. It's fairly complicated, the law around this, but when doing that, it's a decision of the prosecutor, and it's a big decision to make because it can open up other issues like the defense wanting to test that evidence and possibly seeking to cross-examine the report writer or the victim on the victim impact statement. It's not very common that happens, but these are the issues that are raised when the prosecution are thinking about whether to try and have a victim impact statement taken into account in that way on a sentence. When there's been a death, a victim impact statement may also be taken into account by a court to determine a punishment for the offender on the basis that the harmful impact of the primary victim's death has had on a family or on the community. Again, that's a decision that's must be made by the prosecutor. There are also a few other examples where a victim impact statement can affect a sentence. For example, when someone is a forensic patient, a victim impact statement can be considered when determining the conditions of release. So the other function of a victim impact statement, as I mentioned, is expressive, and that is to give victims a voice in the criminal proceeding. As we all know, the role of a victim in the criminal process is limited. They are the complainant. Sometimes they give evidence during a trial or hearing, but even then they aren't telling their story in their own words. They are answering questions as a witness. So a victim impact statement can provide an opportunity to share the impact of the crime in their own words and have it acknowledged and validated. And that can be empowering and healing for some people and provide some closure. After working with a number of victims who have provided victim impact statements, both here and when I worked at the prosecution, I would say no two experiences are the same, and not everybody finds the process empowering. But we can get into that a bit later when we talk about assisting victims make a victim impact statement. There's also an opportunity through a victim impact statement for the offender to gain insight into the consequences of their actions. Victim impact statements are voluntary. It is up to the individual if they want to make one, and it's important for them to know that if they choose not to, the court will not take this take it to mean that they weren't harmed. It also, for family victims, can provide a way to make the deceased person visible to the court. Okay, so who is eligible to make a victim impact statement? This is a really important area as it can raise expectations as to rights, or alternatively, it can be a missed opportunity for a victim to have their voice heard in criminal proceedings. So this applies in New South Wales, of course, and differs from state to state. A victim of crime who suffers harm as a result of the offence can make a victim impact statement if they are the victim of what's called an eligible offence. So it doesn't apply to every offence, but I'll get into that. First, we'll look at what is or who is a victim of crime. So a victim of crime, or what the legislation refers to as a primary victim, is a person who has suffered harm as a direct result of a criminal offence against them. So the harm can be physical harm, it can be psychological harm or psychiatric harm, and there are lots of examples of what kinds of harm that might be, and we'll get into them on the next slide. And then in relation, also family victims are eligible to give a victim impact statement. So a family victim is when someone has died as a result of the act concerned, an immediate family member are also considered to be a victim of crime and are eligible to submit a victim impact statement. This is also the case if the primary victim was pregnant and a fetus was lost as a result of the crime. So there's a definition in the law about who is the primary victim's family, and it's fairly wide definition. It includes a spouse, a de facto fiance, parents, step parents, guardians, grandparents, children, siblings, aunts, uncles, nieces, and nephews. In the case of a victim who is Aboriginal or Torres Strait Islander, it is a person who is considered to be part of the close family or kin of the victim. It can also be a person who the prosecutor is satisfied is a member of the victim's extended family or culturally recognised family, or for who the person had a very close relationship similar to that of a family relationship. So we've got a very wide definition there. And then once you establish if the person is an eligible victim, then they also need to have the offence committed against them needs to be an eligible offence. So this is a bit more complicated. In New South Wales, the eligibility to make a victim impact statement is offence specific. In 2018, the New South Wales Sentencing Council reviewed victims' involvement in sentencing, and they said it was probably impossible to make a list of eligible offences given how complicated it is. I'll try to go into some of the more common offences and in each jurisdiction. But it is, it's a complex area. So in the local court, we've got an offence that results in death, some of the prescribed sexual offences. We have what's referred to as, some examples of the prescribed sexual offences that are dealt with in the local court include aggravated sexual touching and sexual touching of children. So they're offences where people can make a victim impact statement. Also, eligible offences are what's referred to as Table 1 offences, and that's an offence that's referred to in Table 1 of Schedule 1 of the Criminal Procedure Act, and results in actual physical bodily harm or an act of actual or threatened violence. So this is a little bit complicated, but some of the examples include that grievous bodily harm, wounding, choking or strangulation, and some dangerous driving offences. They're sort of most of the common ones that you would see dealt with in the local court. Also, violation of privacy offences. So that might be sharing intimate images without consent or other image and filming based offences. So as you can see, it's a little bit complicated, and it's important to not raise expectations of a victim if they might not be eligible to make a victim impact statement. So I think what we would recommend is that if you think you're working with someone and you think they might be eligible, it's good for them to check with the prosecutor in the matter or for them to get legal advice about whether or not they're eligible. In practice, in the local court, there's a very low uptake of victim impact statements. A study in Victoria found that while the majority of magistrates wanted to see more victim impact statements submitted in their local court, they were of the view that there were a number of barriers. And the study found that it wasn't just a resourcing issue, but a cultural issue and an educational one as well. So we'll just go to the next slide. So in the district or Supreme Court there's a much wider scope to accept victim impact statements due to the more serious criminal matters being dealt with in these courts. Also, the volume of matters that they're dealing with is not as high as the local court. So here again, we have an offence that results in the death or of a person. It also eligible is actual physical bodily harm, an offence that involves actual or threatened violence, or a prescribed sexual offence, or again, a violation of privacy offence. There are different rules, again, that apply to the Industrial Relations Commission and to the Children's Court. I won't go into them here, but like I said, it's a good idea to check with the prosecutor if the offence is eligible offence. So who is eligible to make a victim impact statement? The courts also have discretion to admit a victim impact statement outside the legislative framework, that they can consider. In considering the impact of the crime on the victim, they can allow a victim impact statement to be tendered, and sometimes that does happen in New South Wales outside of the legislative requirements. Though, if a victim was wanting to rely on this, then they should again first contact the prosecutor or get some legal advice. The right to prepare a victim impact statement was enshrined in the 1996 Charter of Victims' Rights. And so, among other rights, it infers the right of a victim of crime to have information about and assistance to prepare a victim impact statement if they're eligible. And everyone working in New South Wales government departments must uphold this charter, as well as people working in non-government agencies and who are funded by the state to provide services to victims of crime. So what can a victim impact statement contain? So for a primary victim, a VIS can include information about personal harm, emotional suffering or distress, harm to relationships with other persons, or economic loss or harm that arises out of the A to C on the list there. So if some emotional suffering or distress has resulted in economic loss, then that can be included on a victim impact statement. The Victim Services website has some examples of what might be some of these different types of harms. So they list under personal harm, changes to your well-being or your view of the world, enjoyment of life, feeling emotions such as anger, fear, sadness, anxiety, or shame, low self-esteem, addiction or eating disorders, lifestyle changes, which is a common one around trouble sleeping. There are also a list of physical examples, so any injury as a result of the crime, wounds, scars, infection, sexually transmitted disease or illness, ongoing medical treatment that might be required, or how seeking ongoing medical treatment has affected your life. So chronic pain, impact at work or sport. Some of the social examples that were given relate to changes to work or study, whether or not someone feels safe as a result of the crime, or changes to their relationships with other people like friends, their family or community. So in relation to what a victim impact statement can contain from a family victim, it's slightly wider than for a primary victim of crime. So a victim impact statement from a family victim, so when there's been a death, can include the impact of the death of the family member on them and other immediate family members. So that might be the immediate grief that they're experiencing, but it's not just limited to that. And the courts in New South Wales have said that this shouldn't be interpreted to be narrow. It's a wide allowance of what the impact can be. I've assisted people with a VIS in this circumstance, and it can be things like not only the impact of the loss of that family member, but the ongoing impact that might have. So, grandparents of a victim, a family victim, have found, that even the loss of potential grandchildren can be one flow-on effect of the impact of their death. For all victim impact statements, the requirements that the legislation provide are that it must be legible, and it must be a maximum of 20 A4 pages. There are certain things that a victim impact statement cannot contain, and the court will only consider the effects of the offences for which the offender has been convicted. So if the victim impact statement refers to the effect resulting from other offences which they weren't convicted of by the court, then those parts of the victim impact statement will not be included in the statement that's accepted by the court. So this can be quite hard in domestic and family violence matters where there's a pattern of abuse, and it's not an incident-based form of abuse. It can be quite artificial for people trying to separate the impact of the crime that the offender is being sentenced for apart from the impact of the overall relationship. But it is important that a victim impact statement comply with the legislation, because if it doesn't, then the defence can object to parts of the victim impact statement and it may need to be edited. Editing a victim impact statement is very distressing and disempowering to victims, and it can be enormously detrimental to the victim and sort of diminish the restorative purpose of giving a victim impact statement. It also increases the very remote chance of the defence seeking to cross-examine a victim. So that is one possibility. It is a possibility when a victim impact statement is submitted to the court. But in practice, it's very rare that defence seek to cross-examine a victim. But a study in New South Wales found that though it is rare in practice, it is still a barrier to victims providing a victim impact statement. So some other things that cannot be contained in a VIS is views about the sentence that should be imposed, anything that's offensive, threatening, intimidating, or harassing. A victim impact statement also cannot contain denials of harm of an offence. That would make it inadmissible, and it doesn't very often come up, but it has come up in New South Wales where a victim impact statement has the victim has aligned with the perpetrator and used the VIS to deny the harm, but given the legislation is there to allow statements about the impact or the harm on the victim, that material is not admissible through a victim impact statement. And then, as I mentioned, anything beyond what is permitted by the legislation, so harm or impact of the crime, is not admissible. So what happens to a victim impact statement? The court can accept a victim impact statement at any time after it convicts, but before it sentences an offender. It's important not to start writing a victim impact statement before the offender is found guilty or pled guilty. And this is simply just to not create more potential material for the offence, about the offence and what happened, because that could lead to further cross-examination or it need to become a part of the proceedings. A victim impact statement must be tendered by a prosecutor. The victim impact statement is served on the offender before the sentence proceedings. This is to see if there is any objection to the content, in the hope that it can be worked out before the day of sentencing. This can be a big factor in victims' decisions whether or not to make a victim impact statement. And there's unfortunately no way around it. Offenders are entitled to see the contents of the victim impact statement being tendered. So they should be sure to what they contain in the victim impact statement. They are happy for it to be shared with the defendant. I mean, other people want the defendant to hear about, or the offender to hear about the harm that their offending caused. Once a victim impact statement is accepted by the court, the statement can be read out by the victim, or an immediate family member or a representative of the victim. It cannot be read out by the prosecutor. In the case of a child, it can be read out by a parent. The reading of the victim impact statement to the court is optional, and voluntary. If that person is entitled to give their evidence via CCTV, they can give their victim impact statement also via CCTV, or they can, if they're not entitled and they haven't given evidence in the hearing via CCTV, they can still make an application to the court to read their victim impact statement through CCTV, to not be in court where the offender is. Also, a victim is entitled to one or more support persons to be present during the court, unless the court says otherwise. The representative of a victim for the purpose of reading a victim impact statement is a victim services counsellor, or somebody who is appropriately qualified by training, study, or experience. So, as I mentioned before, there's the remote possibility that defence can seek to cross-examine the victim on the statement, and that would be if they do not agree with parts of the statement, though in practice this is very rare. But I guess it's important for victims to know that it is possible, though remote. And the victim impact statement is kept on the court file, but it's not kept by defence at the end of proceedings. They must destroy it at the end of the proceedings. And if an offender is self-represented, they can view the victim impact statement, but they are not permitted to keep a copy, make a copy, or to disseminate the victim impact statement. Assisting someone with a victim impact statement. So I think the first question when assisting someone with a victim impact statement, of course, is, are they eligible to make a VIS? And if it's unclear, and I could understand why it would be unclear with the eligibility sort of framework that we have in New South Wales, I would refer that person back to the prosecutor. And so that will either be, for serious matters in New South Wales, the Office of Director of Public Prosecutions, or for other matters that are most being dealt with in the local court, the police prosecutor. And they can get some advice to make sure that they're eligible to make a victim impact statement. If they've experienced domestic or family violence, you could refer them to us at the Domestic Violence Unit. Otherwise, a community legal centre or Law Access may be able to advise them. I think then an important area of assistance for someone considering making a VIS is with the decision-making process. It's a difficult decision whether or not to make a victim impact statement. There's no wrong choice, and it should be the choice of the victim. Some people find the process empowering, other people find it re-traumatizing. Some other words that have been used to describe it have been therapeutic, frustrating, disappointing. So giving someone support to make that decision and being clear that there's no guarantee that they will feel empowered, but that it is their decision to make, and one of the few decisions that are in their hands in relation to the prosecution process. After the decision about whether or not they want to make one, there's a second decision about whether or not they want to read the victim impact statement out loud in court, or whether they want it to be tendered to the court and form a part of the papers that the judge or magistrate will read. I think providing information is very important. Early on, what can go in and what can't go in, where the victim impact statement goes, can really assist expectations. Allowing them to, or explaining that generally it doesn't increase the sentence is important, I think. And I guess the more information a victim has about what can go in a victim impact statement reduces the risk of there being material in there that's not admissible and resulting in editing later on, or objections from the defence. So if someone wants to make a victim impact statement, then let the prosecution know as soon as possible. The more time people have to prepare the victim impact statement and for the prosecution to review it and then serve it on the defence, the less likely there'll be any last minute amendments, which, as we talked about, can be very distressing. If a victim is incapable of providing a victim impact statement because of age, impairment, or otherwise, a victim representative may assist, prepare, or read a VIS on behalf of a victim. So that can be a parent, immediate family member, a carer, an important person in the victim's life, or any other person chosen by the victim. So also, this point came from one of our social workers in the domestic violence unit, and I think it's very important, creating an emotional safety plan for victim impact statements for the person, for when they're drafting it and also reading it if they decide to read it. We know that it's likely that the process is going to be re-traumatizing. So what plan can you put in place with the client to manage and minimize that distress? How can you support the client through this difficult process? How much involvement do they want? Some clients might like to write it on their own. Others might like more support. They might want to practice it with you. What kind of practical support do they need to prepare a victim impact statement? Do they need interpreter support? Do they need access to a computer, pen and paper? Are there literacy or communication issues and they need assistance with writing? Do they want you to liaise with the prosecutor on their behalf? Will they like to read it out via CCTV, have a support person there? It's important that as organisations that we are clear and upfront about what are our boundaries and limitations of our role or resources. Can we provide someone with in-court support? And if we can't, can we refer them to a service that can? Also, it's an opportunity to connect with someone and make other potential referrals to support them. So that might be counselling or for some financial support through victim services. And then finally, what can you do with the things that can't go into the victim impact statement? So if there are things that they want to say but they can't go into a VIS, can they put it in a separate document? They might want to read it out to you or to family and friends. They might want to burn it. But that's their own story and that can't be changed. This is really important. And I think in many offences, but for example, in domestic and family violence, when we know that what might be going through the court is rarely a reflection of what their actual abuse and situation has been like. Also, when there has been some negotiation between the prosecution and defence and charges might be dropped, or there's or there's been plea negotiation and they might enter a guilty plea to a lesser offence. In those circumstances, again, it can limit what is allowed into a victim impact statement. So putting all of the impact of the crime in another separate document might be a way of addressing the issue of not being able to include it in the VIS. So in a survey conducted by the Victorian Victim Support Agency, stakeholders acknowledged the important and valuable role that a victim impact statement plays in this sentencing process. And they said that there were a number of factors which can affect a victim's level of satisfaction with the process of making a VIS, and they included the extent to which they are aware of their right to make a VIS, their understanding and expectation of the VIS process, in particular how the victim impact statement would be used, whether they received adequate information and support to prepare their VIS, and how their VIS is presented to and judicially acknowledged by the court. And I think these are all important considerations for us working with victims to keep in mind that our role in working with a victim can have a big factor or can increase the level of satisfaction they have in engaging with this process. Also, the legislation now requires the court to acknowledge the receipt of a VIS. So that change was brought about in relation to victims, saying that it was important to them how the court responded to and acknowledged their victim impact statement. So there are some resources available about victim impact statements. The victim services have a victim impact statement guide on their website. They also offer counselling and financial support to eligible people, and you can contact them through the Victims Access Line. New South Wales Police also have an information sheet on their website for victims of crime, which talk about a victim impact statement. And the Office of the Director of Public Prosecutions also have a brochure on their website about victim impact statements. So we'll send that information out in an email at after the webinar. Also, as I mentioned, if someone has experienced domestic and family violence, they can contact us directly for free confidential legal advice. And I've got our number and email there for referrals, so we can accept referrals from community workers, or clients can contact us directly. We also have duty solicitors in a number of local courts in New South Wales and in the family courts across New South Wales. We have duty solicitors available to give people advice there as well. So I think that's all from me. Should we open it up to questions now?
Yeah, thanks, Julia. There is a question. So when you spoke about the rare possibility of a victim being cross-examined on a victim impact statement, there's a question from a participant who would like to clarify, were you referring to cross-examine in relation to evidence provided or cross-examination in relation to the VIS?
Well, it's cross-examination on the content of the victim impact statement. It's very rare, and it's yes, mostly if the defense objects to some of the content in there, so if they think maybe what's in there might go beyond what's an impact from the offence, though I would suggest it's very difficult for them to challenge the actual harm caused by a crime, because I'm not sure what basis they would have to challenge that material. But if they did have an objection, hopefully those issues could be resolved in negotiation before the sentencing hearing. So they might say, okay, this sentence or this particular paragraph we object to, and then the prosecution would go back to the victim to talk to them about it. And it might be the case that it's edited to resolve the need to have the victim go into the witness box and give any evidence and be cross-examined about the impact of the crime. Yeah, so it has happened in New South Wales, but it is very rare.
I guess it
And
highlights the importance of managing expectations and making sure that it complies with what the legislation says.
yeah, that's right. So it's a minimal, it's a very remote risk, and it can be managed by making sure it complies or trying to address the issue before it goes to a sentencing hearing. And at any point, of course, the victim has the right to decide not to tender a victim impact statement. I've had victims decide that towards the end. I've also had victims seen a victim get into the witness box to read out their statement and then decide that's not something they could or were able to do. So there are opportunities to stop things before they get to that stage. Yeah.
Thank you. At this stage, that seems to be the only question that we have. Oh, there's another one just come in. Would the DV unit or other solicitors be able to provide assistance in reviewing a victim impact statement to ensure the content is relevant or eligible?
Yes, I think we could give some feedback on what the law says and whether or not it complies in a general sense. One of the issues about giving legal advice for us is that we might not have the information about like what the offender has pled guilty to, or what the agreed facts might be in a matter. So um, it depends on the matter, but it might be better to get the prosecutor to review it, because they will be familiar with what the person has pled guilty to or been found guilty of. But certainly there are some requirements that we could easily give feedback on around, whether the harm they're talking about complies with what the legislation allows, things like that.
And that would be for clients who've experienced domestic violence for your unit to become involved.
Yes, that's right. So domestic or family violence, if they haven't experienced that, then and their matter's been dealt with in the local court, I would recommend, the police, prosecutor, or a community legal centre. If their matter is in the district court and it's being managed by the Office of the Director of Public Prosecutions, then they have a witness assistance scheme, where they have social workers and other workers that are able to provide support and advice to victims, and they're very familiar with supporting people develop a victim impact statement. So they would be able to assist, or the solicitor, with carriage of the matter for the Director of Public Prosecutions. So if it's a serious matter that's being dealt with by them, I'd recommend going straight to the DPP for that assistance.
And just to let everyone know, I'll include some information, contact information for the witness assistance scheme in the email that comes out. There's another question. Are there visa-related eligibility requirements for someone wanting legal advice at the DVU or ongoing representation support from legal aid?
No, there aren't. So we have our initial phone advice, or if someone drops into court, a family court or the local court where we are, it's free, it's merit-based, it's confidential. So I'd really encourage anyone, particularly if they have a temporary visa or not regulated visa, I would really encourage someone to get in contact with us. We actually have a special project in the DVU that's working with people on temporary visas. So we've got workers that have can give immigration advice as well as advice around domestic and family violence. In terms of ongoing representation from legal aid, there's a number of different tests that that are applied to people seeking us to represent them in ongoing matters. It's not related to visas, but it is. There are sort of merit tests and means tests, but we can explain what those tests are, and we can advise people whether or not they will be eligible for legal aid. So again, I'd encourage them to get in contact with us.
And of course, if there are questions around a visa, but there isn't domestic or family violence involved in civil law, there is the specialist immigration team in as part of the government law team. So the person may be able to get some advice from that team as well. And I know that the refugee service in legal aid also assists people in relation to visa issues for clients eligible for that service.
Yeah, that's right. So yeah, they should definitely get in touch with us, and they can contact us through Law Access as well, and they can refer them to the right path.
Okay, I think that's looking like all the questions that we have so far. I'll just go to the last slide and just let people know, in case you're not already a subscriber, that you can subscribe to the Law for Community Worker alerts, and then you will receive information about the latest podcasts that have been issued, and you'll get information about recorded webinars, because all our webinars are recorded and are uploaded onto the Legal Aid YouTube channel. And everyone, you will receive an email following the webinar, and it will include links and telephone numbers to all the different resources and services that Julia has referred to during the webinar today. But it looks like at this stage, that's all the questions we have. So of course, people are always welcome to email a question that they think of later to us at the CLE branch. And otherwise, I think we'll close off the webinar, and thank everybody so much for attending today.
Great.
Thank you, Julia. Great presentation.
Thanks, Bridget. Thank you, everyone.
Bye, everybody.